the people of the state of New York versus Ryan Brahney. Good afternoon, Counsel.
Good afternoon. May it please the Court, Catherine Friedman, representing appellant Ryan Brahney on this particular appeal. Your Honors, this appeal comes to this Court from a two-justice dissent at the Appellate Division 4th Department, and it really comes down to the separate and distinct formula pursuant to this Court's decision in People v. Laureano.
But it's really not the formula, right? I mean, the formula is the accepted one. It's the facts of this case, it seems to me, it comes down to.
Your Honor, I think that there is a legal question before this Court.
Which is?
And it is whether the people met their burden of demonstrating that concurrent sentences are not applicable in this particular case. That's, in my view, that's the legal issue before this Court.
Well, right. I'm sorry, go ahead.
No, you go.
And what I understand their proof on was that was among the blood evidence upstairs, and downstairs here was also the defendant's statements that I killed her downstairs. So they have this burden to come in and make this showing under our well-accepted rule. They brought this evidence forward. Our role can only be that what's our standard for reviewing that, which the trial court, sentencing court found was affirmed by the appellate division majority. What do we do with that?
Again, I think that you are in a position to determine that the people did not meet their burden.
That there was more blood upstairs than downstairs?
I think the point of the appellate division justices was that there needed, because of there was the possibility.
But is that the standard, that there was a possible view of the evidence that would have been something else, which actually was less supported, it seems, than the large amount of blood in the statements of the defendant?
So, Your Honor, I've actually thought long and hard about this issue. And it seems to me that the standard under the statute and under Laureano, again, is whether the people met their burden of establishing that concurrent sentences do not apply.
And that means separate and distinct acts, right? That's what we're talking about.
And that means separate and distinct acts. Now,
okay, so in order...
Excuse me one second. Ms. Friedman, I'm sorry to interrupt. Did you intend to ask for a rebuttal time? I don't want to cut you short.
3 minutes? 3 minutes?
Yes,
rebuttal?
you may.
Okay.
Excuse me, Judge Stein.
Wouldn't your argument require that the victim barely bled in the location where the fatal blow was sustained, and in your view, that could have been upstairs, okay? So one of the blows that punctured her internal organs would have to be upstairs, but where there was very little blood, but that she bled profusely when she got downstairs, including after she died, and her heart stopped. Wouldn't your view of the acts have to result in that conclusion?
Well, I think that's certainly my colleague's argument, Your Honor. I actually think, though, that if we look at the statute and if we look at Laureano and we look at the way
I'm
that it's
asking you to look at
worded,
the facts of this case, because that's what you're asking us to do, is to determine whether the people met their burden.
yes, Your Honor.
So given what the people did prove, and Judge Garcia summarized that for us.
Yes. Well, Your Honor, again, the justices at the appellate division determined that because there is the possibility that the same act of...
Let's try it again, okay? Because I understand what the appellate division said, but in responding to my question, is that what would have to have happened in order for your view to win the day?
I think that that is one scenario that would be likely. I think that again, if I could go back to,
Let me just take a second here, all right? I just looked at the dissent again. I'm looking at the dissent at what Judges Sentra and Lindley said, and it seems that what they're saying is that if there was one stab upstairs, that one stab could have been a death blow, and therefore it could have been the same.
that's correct.
And the problem that both Judge Stein and Judge Garcia pointed out is that, but the bulk of the evidence shows that there were, so that would have meant 37 stabs were downstairs, but one stab was upstairs, and therefore we could say that the sentences were required to be concurrent because they weren't separate and distinct acts. That's the core of your argument.
That's correct.
Okay. You see why that strains credibility a little bit?
I believe that there certainly is a stretch to the
Well,
imagination
it's not just that. You
there.
have the photographs, you have the statements to his mother, and then, of course, you have the blood splatter, the blood evidence itself. So those, and then there's, well, those are the three strongest pieces of evidence, I think, right?
That's correct, Your Honor.
What is the people's burden? Is it preponderance or
You know, that is a really, really great question. I was not able to find the standard for the people in terms of meeting their burden, but it's almost as if the statute and the case law suggest, and I hesitate to use this word because this court has never used these words, but it's almost as if there's a presumption that concurrent sentences apply, and that the people have to rebut that presumption. Now, again, that's sort of an analogy that I'm using to try to get my head wrapped around the people's burden and exactly what it is. But if there is,
So are
if
you
it's
saying
that
if
high
there's
of a bar,
any possible view of the evidence, is that your argument, that the standard is if there's any possible view of the evidence and the people have not met their burden?
that's correct, Your
You
Honor.
know, that'd be a higher standard than beyond a reasonable doubt.
That's correct, Your Honor.
I see.
Any further questions?
Thank you, Counsel.
Thank you.
Counsel?
Good afternoon, Your Honors. May it please the court, Chris Valdina for the people. With all due respect to the dissenting appellate division justices and to this court, I think this is a case that probably should have stopped in Rochester because, as the court pointed out, it's all a factual question.
Counsel, going back to Judge Wilson's question, what is the standard that people have to meet?
This court's cases have stated we have to identify facts in the record supporting the basis for consecutive sentences, that there were separate and distinct acts.
just some facts, not preponderance?
The court has never said that a standard of proof in terms of preponderance, clear and convincing evidence, or at least I haven't seen it in my review of the cases. Usually we just have, or what the court says, we just have to identify facts. I suppose if it could go either way, then the presumption would be in favor of the defendant. So if I suppose in those terms it would be a preponderance standard. It's not an element of the offense. Well, if it is an element of the offense, we have to prove it beyond a reasonable doubt, obviously. But you can have it be an element and have it be not a separate and distinct act or be a separate and distinct act. So as long as it's not equivocal, would be my point of view. We have to identify facts that are not equivocal, which I guess that would come down to a
But
preponderance.
it is your position that the evidence goes against the death blow, what Judge Fahey called that death blow theory?
There's
We
no,
don't have to concern ourselves necessarily in this case about what's the standard, because there's no evidence that supports death blow.
correct, Your Honor. In this case, there's just, it would be physically impossible and against the laws of anatomy and medicine for that to have occurred. I mean, you have so many factors in favor of separate and distinct acts. You have the comparative quantities of blood, you have the defendant's admission, you have the defensive wounds on the victim's hands, which were established both elements, that she's, or both burglary counts, that she's being threatened with a knife, he's using the knife against her, and he inflicts
Would this
physical.
be a closer case, counsel, if there were no upstairs and downstairs?
It would be, I mean, I think the fact that you have more blood in one location than another location, whether it's upstairs versus downstairs is of course, doesn't really matter. I think even if you didn't have all that, the defensive wounds alone, because they're physical injuries, they're ante-mortem, they're showing that the defendant is wielding the knife, using or threatening the use of the knife against her. That alone would establish that the burglaries had been completed prior to the homicide, because the doctor never said that any of the 38 wounds could have been fatal. He just specified that any of the wounds to the neck, chest, or back where vital organs and major blood vessels were injured could have been fatal. So there are numerous injuries that were ante-mortem, non-fatal injuries, and at that point, both counts of burglary had been completed through separate and distinct acts.
Would we be in a different place if you had pled the burglaries in a different way, not specifically with the aggravating factors, the physical injury and the dangerous instrument?
Well, if you'd had a burglary second degree, that would have been like Frazier, it would have been complete upon entry, so then it wouldn't even be an issue at all. If you had a case where there was only a single act, where all he did was stab her once and that was a fatal wound, then I don't think we would be able to argue separate and distinct acts. But here, the very elements of those statutes, coupled with the facts of the case, resolve any issue. So unless the court has any other questions.
Thank you, counsel.
Thank you.
Counsel? Any rebuttal?
Unless the court has any questions for me.
Thank you.
Thank you.